Do you know who in your office now handles petitions to come off the registry? Mr. Getachew Smith used to do that. So defendant X had to register, but he's done with his sentence. It's been 5 years. Statutorily, you can petition to come off, and Getachew Smith would handle those.
I've seen that just the regular SAG will do it. Well, it depends. If it is a registry for a shopping place, then.
Yeah, it was some crime out of Illinois from a long time ago, and the guy's done with it. I don't remember it. It's not your case originally, but he lives here now. And basically, you guys are in default. This guy filed the lawsuit. It's a civil suit. He served your office and no one answered. And so he's saying, I should get to deregister as a matter of default, which is not going to happen. I'm going to have a hearing. I need to know who to drag from your office in. And I've made a couple other inquiries, but if you don't mind just reaching out, like, who should McBurney contact?
Probably going to be, Judge, it's probably going to be Caitlin McGillicuddy or Siri Patel.
That's my thought.
Depending on.
Which, that's why I said.
It just depends on what his underlying offense was?
If it's
All right.
a child-based offense, it would be Caitlin McGillicuddy. If it is an adult-based offense, it would be Siri Patel.
Okay, and it's not someone in the appellate section, because Getachew Smith was an appellate guy. And
No, when I see, because I've seen a hearing for that, but it was in Judge Matthews' courtroom, and Ms. Nix actually handled it, but it was an adult.
Okay, well, I can find that out. It listed whatever it was in Illinois, and we'll figure it out. Okay, Mr. McGlone, I'm sorry. I didn't mean to take up your time with that. I was letting Ms. Willingham get ready, and then I was interrupting her getting ready. So let's get on the record in your cases. Mr. McGlone, you have 25 SC 005805, a case in which you're charged with aggravated assault, a couple other offenses. And then 25 SC 006410, a case in which you're charged with aggravated stalking. Ms. Rios represents you in both those cases, and she's standing right next to you. Ms. Willingham is going to handle both cases, I think, for the state. She's going to put you under oath in a moment, ask you questions about you and your case and your rights. You need to answer those questions truthfully. You also need to let me or Ms. Rios know if you have questions while we're going through this. Will you do that?
Yes.
Okay. You ready to go?
Yes, sir.
All right, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please, I'm sorry, you can put your hand down. Please state your true, correct, and legal name.
Cody Mauricio McGlone.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
34 high school diploma.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Have you reviewed the indictments with your client?
Yes.
Do you waive formal reading of the indictments?
Yes.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding
No.
warrants
You were
related to
arrested?
these charges.
How did you get here?
That's that's the question. I was never arrested on aggravated stalking or aggravated assault.
You were,
All right, I'll look it up in just a sec.
You want me to keep going, Judge?
Yes.
Okay.
We asked that question more so just to make sure there aren't warrants out there, not to say, haha, this case never happened.
Well, originally had an FTA for the aggravated assault. The stalking got added on because I had gotten into another incident with the same victim.
That's where aggravated stalking comes from.
Yeah.
Okay.
The state is unaware of any outstanding warrants related to these charges. Do you or your your client know of any outstanding warrants related to these charges?
No.
Mr. McGlone, do you understand you're entering a plea of guilty to the following offenses? As to indictment ending in 805, aggravated assault, family violence, criminal damage to property in the second degree, and battery, family violence, first offense.
Yes.
And as to indictment ending in 6410, aggravated stalking.
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court an overall sentence of 5 years to serve 1 year? As to indictment ending in 805, count 1, 5 years to serve 1 year. Count 2, 5 years to serve 1 year concurrent to count 1. Count 3, serve 12 months concurrent to count 1. And indictments ending in 410 will run concurrent with indictment ending in 805. And the sentence for that will be 5 years to serve 1 year. The state would be recommending that you have no contact with the victim, referenced by the permanent protective order you've signed, that you would be required to complete family violence intervention program, complete 60 hours of community service, seek and maintain gainful employment.
Can you repeat the conditions one more time? I got the 5 serve 1.
Yes. Permanent no contact as referenced by the permanent no contact order.
Yep,
Complete family violence intervention program.
yep.
Complete 60 hours of community service.
Hmm.
And seek and maintain gainful employment.
Okay, thank you.
And Your Honor, the state would note for the record that we do understand that the parties share children in common. However, it is my understanding as of today, those children have not been legitimized. Ms. Williams will be seeking that. She does understand they will ultimately need a third party, but she was very adamant that she does want this permanent no contact order put in place.
Okay,
So I just wanted to, because I recognize that may create some kind of an issue, but my understanding is their communication can still be through a attorney.
Right.
and we would not have an issue with them appearing in court at the same time, obviously, but
okay. When you say they haven't been legitimized, I think it's legitimated, but I'm learning this. Meaning, they are very clearly Ms. Williams's children. She birthed them. She may not be disputing that Mr. McGlone is the father, but legally, he's not the father yet. That may happen, in which case they would need to go to court to figure out shared custody or however that's going to work. But as of this moment, Mr. McGlone does not have a legal claim to spend time with the kids.
correct. And
Okay.
it is my understanding that she will be seeking that.
Or she will want the,
Yes.
okay,
Because that has
legitimation.
to happen for child support purposes as well.
Okay.
So I do know that she will be seeking that, but that's why I wanted to make sure that that is also noted on the record. Were those the conditions explained to you?
Yes.
And are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that if you do not accept the court sentence, have we had final plea? Have we had final plea?
No.
No.
Do you understand that if you do not accept the court sentence, you may withdraw your plea? You may withdraw your plea today?
Yes.
Okay.
This is a negotiated plea.
It is.
Right. So if I sentence you to more, if I sentence you 5, do 2, you'll have a chance to talk with Ms. Rios about it. And if you would rather go to trial on these cases, you can walk away from the plea. If I go along with the plea or go below it, you're locked into it. But if I'd say 5, do 2, 10, do 5, anything like that, first you'll get a chance to talk about it. And then if you say, let's go to trial instead, you have the absolute right to walk back that plea and no one will know what ever happened. Meaning the jury would never be told that. And we'll just get you into court someday to do a trial. Okay?
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation of the balance of this sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you further understand, because there are family violence convictions, that you will not be allowed to have a firearm, and if you are found in possession of a firearm, you could be charged federally?
Yes.
Are you on probation or parole for anything, anywhere?
No.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of aggravated assault, family violence, criminal damage to property in the second degree, and battery family violence first offense in indictment 25 SC 005805?
Guilty.
And how do you plead to the charge of aggravated stalking in indictment 25 SC 006410?
Guilty.
And I'm gonna go back. Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced pursuant to the First Offender Act?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
And Your Honor, for the record, the state would be deferring to the court as to whether the defendant can use first offender on both charges. That was the discussion between the state and the defense on that.
Okay.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, as to indictment ending in 805, if this case were to proceed to trial, the state would expect to show on June 17, 2024, at approximately 1800 hours, Officer Jones was dispatched to the incident location in South Fulton, Georgia, Fulton County, in response to an assault call. Jones met with the victim, Miss Williams, who stated that her children's father, identified as Mr. McGlone, came to her home unannounced and assaulted her and damaged her vehicle. He entered her home while Williams was downstairs working and continued to verbally argue with Williams. Williams stated that McGlone snatched her work laptop out of her hand and broke it in half. She stated that McGlone began to hit her in the head, face, and ears multiple times. Williams stated she ran upstairs, grabbed her gun, but McGlone was able to wrestle the gun away from her. Williams then ran outside and called 911, with McGlone following her outside. McGlone went over to Williams' vehicle and stabbed her two passenger side tires with a knife. She stated that McGlone got into his vehicle and tried to hit her and fled the scene. Jones observed red bruising on the left side of Williams' face. She also saw the black laptop broken in half. Jones reviewed surveillance or ring camera footage of a black male subject exiting the residence, stabbed both of the tires of a silver Lexus. The video showed the same black subject get into a gold sedan, back out of the driveway, and drive towards a female who was standing slightly in the road. McGlone has had two open misdemeanor cases involving the same victim, Miss Williams, pending. And as to indictment ending in 6410, the state would expect to show that on September 7, 2024, Officer Paul responded to 6743 Marywood Drive in reference to damage to property. Upon arrival, they met with Miss Williams, who stated that the father of her children, Mr. McGlone, assaulted her in Clayton County at a party, then broke into her house. And Your Honor, at the time of that contact, Mr. McGlone had an active bond order that was issued on, I'm sorry, I'm thinking.
Was it a bond from the 805 case, or was it one of the
No.
Judge Morrison state court cases?
Yes, it was the state court case, Your Honor, and that was issued on. It looks like it was issued on June 21st of 2021. And it was still in place at the time of this incident, and it had a no contact with Tiana Williams. And it also listed in a stay away from that incident location. The defendant was to have no weapons, drugs, or alcohol. And Your Honor, I have talked to Ms. Williams. Initially, when her and I first spoke, I explained to her that I would actually probably be asking for more time. The defendant had an open state court case, and there were literally 3 cases pending at the time of this. We had 3 cases pending at the time we had plea and arraignment in this courtroom. And ultimately, in our last communication, although she did want him to spend more time in custody, she didn't at the same time, because although she wants no communication with him, she does feel that she needs him to be out and be able to get a job, because she wants to be able to seek child support, and she does want her children to be able to have a relationship with him, which is why she does plan to go through that process with the family court. And she kind of went back and forth about it for a while, but that was our last conversation. And when I followed up with her again, she still feels the same way, that although she does recognize that she agreed I probably could get more time, but she would prefer that he not be in custody much longer, so that she's able to actually start to pursue some things on the custody side.
Okay. How many kids do they have together?
I believe she told me 2, but I'm actually going to lean to Mr. McGlone to
All right,
confirm
we'll
that.
find out from the source. We'll get to you in just a second.
Okay.
All right, so you've received input from Ms. Williams. She's torn. Part of her would be fine if he went away for a long time, but she loves her kids and wants him to support them, but also wants them to have their father in
Yes.
their life. Okay, well, I get that. Thank you. Any felony convictions at this point for Mr. McGlone? No. All right. Ms. Rios?
Yes, Your Honor. Mr. McGlone is 34 years old. He has 2 children, ages 11 and 5, and they're both girls. And before he was arrested, he was working as a forklift driver. He is also has his license and certified, and he plans to be able to
His what license?
his forklift license.
Oh, okay. He is a forklift driver with a valid license.
Yes, Your Honor.
Okay.
Prior to that, he was also a manager at a warehouse and has had several logistic jobs. So when he is out, he is going to be able to work.
Yep.
A part of the reason why I'm asking for both cases to be treated as a first offender. I do understand his history. I understand that he had misdemeanor cases. This all it's not like he has these situations and then a whole bunch of other stuff. It's that all is connected to his toxic relationship with the mother of his child. And I know one of her concerns is him being able to work, and he has a better chance of getting a better job without having a felony conviction, and then he can better provide for the children. So I think that serves everyone if he's able to do that. And if he has an issue again and contacts her, you can revoke him on first and resentence him. So he has a good incentive to not to have any other issues with her. And I believe most of his cases were about 2 years ago. So it hasn't been nothing as of very recent. Double check, but I believe nothing as of very recent. This is all from stuff from 2024 is my understanding. So I ask that you accept the plea as negotiated and let both cases be under the First Offender Act.
Okay. Mr. McGlone, do you have any questions for me about anything we've discussed?
No.
Do you have anything you want to add to what Ms. Rios said?
I want to basically just say it was a toxic situation that I moved on from.
Okay.
I just want to get back to the children and be a father to them.
All right. What are their names?
Kendall and Morgan.
Kendall is the 11-year-old.
Kendall is the 5-year-old,
Morgan's the 11-year-old.
11-year-old.
Okay.
Yes, sir.
Do they come visit you at all right now in custody?
No.
No. Okay. Do you have kids in any other situation, or this is it? Those are your girls.
Yes.
All right. You understand that going forward, you will be able to have them to some extent in your life, but you won't be dealing directly with Ms. Williams for that to happen.
I understand.
She controls the cards right now,
Yes.
but if there is a legitimation so that you're shown legally to be their father, then you two, Ms. Williams and you, can sort out how custody will be shared. You certainly will have child support obligations. There'll be a judge in the mix and ideally some neutral representative, because you aren't to have contact with Ms. Williams. You don't call her to say, when can I see Kendall? I'd like to do this. There'll need to be some third party who's designated, and the court can help you with that, or a lawyer can help you with that, whether it's, I'm making this up, her aunt or your sister or whomever. And that's the person who would do it. But even though you could be reaching out for something as innocuous as, hey, they don't need diapers, they're older than that, but I'm helping out with X. You can't reach out to her that way.
How about reaching out? Because the oldest girl, she has a cell phone. Last year or so, I've been communicating straight through her. I haven't even called.
Your daughters are not covered by the no contact. Okay. But what you cannot do is use your daughter as a conduit. Hey, tell your mom that I want to see you on Sunday. Okay. Because then your daughter goes in the room and says, Dad says, and the moment she says that, that's you communicating to your mom, to Ms. Williams, her mom, And again, you may be very well intentioned, like, hey, just check with your mom if I can get you this weekend. That's unless the court or you and Ms. Williams, but you can't, there's no way you can interact with her. So someone, a lawyer, a neutral, a judge is going to say, here's the intermediary. They rarely designate it as the kid unless the kid is biologically your kid, but is 22 years old.
Gotcha.
But you don't need to go through her mom to get in touch with your 22-year-old. But for even an 11-year-old, even though she's got her own phone, nothing wrong with you contacting her where you will trip up. And if Ms. Williams is feeling a certain way about you, she could not incorrectly say, hey, he violated this. And that's your quickest way back to jail is Ms. Williams being able to demonstrate to the state, hey, he had contact with me. He called me directly, or he gets my daughter to put it on FaceTime, and then she holds the phone up, and oh my gosh, there's his face. That cannot happen. Well, let me just put it this way. If it does happen and Ms. Williams reports it, that's curtains. That's bad news for you. So feel free to contact your daughter, but don't, even as unintentional, like, hey, tell your mom Merry Christmas. None of that. And you guys will figure out through the court system who that intermediary is for arranging visits, contact, that kind of stuff.
Okay.
All right. Well, Mr. McGlone, I find there's a factual bit. Did you have other questions?
Yes, about the plea.
Okay.
The 5-1, is it prison time? I would like it to be county time.
So here's how that works. You will get credit for the time you've been in, and you are getting awfully close to 6 months of credit. Generally, but I'm not the sheriff and I do not control the sheriff, if what remains is 6 months or less, they just say stay put, because it's expensive to get you to Jackson. And by the time they do intake and figure out, hey, let's send McGlone to, time's up. Because you're parolable, and so they may look at you with only 6 months left on your sentence and say, let's let them out. And so why did you go all the way down to Jackson? I just can't guarantee that you're right at that edge. So is it possible that you stay local? It is. Am I promising that? I am not.
Thank you.
You're welcome. Other questions?
No, that's it.
Okay. Well, Mr. McGlone, I find there's a factual basis for both your pleas. It sounds like, and I'm sure there's another side to the story, but on that situation in June, you lost it and really took it out on poor Ms. Williams' belongings. And then what happened a few months later, you needed to be staying away and you didn't stay away. I'm glad no one got too badly hurt. Sounds like you did put your hands on Ms. Williams. One of the many reasons we're building these barriers is so that something like that doesn't happen again. So I do find there's a factual basis for both cases, and your pleas are knowing and voluntary in both cases. You've understood what we talked about, and you've decided on your own free will, that you want to enter pleas in both cases. Is that correct?
Yes.
I will accept both. Ms. Rios, can someone in my office sign both indictments for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And Mr. McGlone, can we electronically sign your name indicating your plea in both cases?
Yes.
All right. So in terms of first offender, given the fact that there are a couple misdemeanors out there that I've seen with Judge Morrison involving Ms. Williams as the victim again, I will give you first offender on one of the cases, but not both. I don't know if it's significant which one gets first offender, so you may want to talk with Ms. Rios. Do you want the ag stalking to be first offender or the ag assault? And the main benefit to you of first offender, since the other case isn't going to be first offender, is that one can be sealed up so that if an employer is checking your history to say, hey, can we hire this guy at this warehouse, they won't see that one at all. The other one, they'll see you got a conviction, but you're going to tell them that in advance because you'll put it on the form so you don't surprise them, and then they think you're not being candid. And I will give you first offender on whichever one you want. I think that's a smart call.
Yeah.
So I'm going to start with the other case because it's lower in number. In 25 SC 005 805, I'm sentencing you on counts 1 and 2 to 5 years to serve 1 year with a balance on probation. Count 3 is it's 12 months to serve, to run concurrently with those other 2 counts. So total sentence, 5 serve 1, exactly what you negotiated. You'll get credit for the time you've been in custody. Special condition number 1 is a permanent no contact with Ms. Williams. That goes on forever until you come back to me through Ms. Rios and you get it changed. And it could well be that Ms. Williams wants it to be changed, and I'd hear that through the prosecutor because she is okay meeting at McDonald's to exchange custody of the kids. And it's just easier for both of you if you two can do that. But until that condition is changed and this permanent protective order is modified, if Ms. Williams says, hey, meet me somewhere, that's a trap. And I don't mean to suggest she would trap you, but she may have forgotten about it or just say, hey, it's easier to do that. You need to protect yourself because you could show up and she just goes click and there's a picture of you within 5 feet of her, which is blowing everything up.
Yes.
And Judge,
You
my
seem
apologies.
concerned about that.
Yes, the permanent no contact statutorily can actually only go on the aggravated stalking. It can be a no contact.
Okay. Great. That's a clarification. So there's a condition of no contact on your ag assault case. It's just not where this order goes, but the order is still there and you're going to need to comply with it. 2 other conditions. You're going to enter into and complete the family violence intervention program. You need to start that within the first 4 months of your probation. So when you get out, you get a little chance to get settled, but within the first 4 months, you got to enroll in that program. It's a series of classes. And you'll need to complete 60 hours of community service. Those you'll need to do within the first 8 months of probation. So we're front loading things, you get those out of the way, and then probation will be no sweat for you.
Okay.
In your other case, 25 SC 006410, I will sentence you as a first offender. So you understand the benefit. That means that it's not a conviction. You can have it sealed. And if you successfully complete your probation, it basically disappears.
Okay.
The risk of first offender is that if while you are under sentence in that case, you mess up and get arrested for something, in particular, anything to do with Ms. Williams, not only are you sideways with probation, but I could resentence you because you pled guilty all the way to the max. And you have a hearing, but you don't get a trial. So you could go from 5 to 1 to 10 to serve. If you're pretty sure you're going to have no trouble staying out of trouble, first offender makes a bunch of sense. Do you want to be sentenced as a first offender?
Yes.
Okay, I'll do that with the aggravated stalking case. Your sentence and the only count there is 5 to serve 1, balance probated. Again, you get credit for time you've served since that arrest. And 3 special conditions. 1, you will abide by the permanent contact order, no contact order. That's what I've just signed. You signed it as well.
Mm-hmm.
That's the forever order. This lasts until it is set aside or vacated or something like that, which requires court action, not just Ms. Williams and you saying, hey, let's ignore that protective order. Condition 2, that family violence intervention program, again, enroll in it within the first 4 months, and then 60 hours community service. It's the same 60, it's not 120.
Okay.
And you got to knock those out within the first 8 months of your probation. Ms. Willingham, anything else in connection with Mr. McGlone?
Nothing from the state, Your Honor.
Okay, you don't sound so good.
I have to cough.
Okay. Ms. Rios, anything else?
No, Your Honor.
Mr. McGlone, any questions?
No. Thank
Okay, good luck with things.
you. Thank you.